program is rated GE. Content carried in here is suitable for general family viewing.
I'm managing projects for computers for schools. Capacity building, and of course electronic waste management. With the old devices now became a big challenge.
We are here live at Kenyatta University School of Law at Parkland campus. You're watching us live at KETV Kenya. Remember, you can interact with us on our social media platforms at KETV Kenya on Facebook, at KETV_Kenya on Twitter, and KETV Kenya on YouTube. Tonight, we are having a very interesting topic on labor relations. What does the law say concerning the issues of labor relation, especially after the promulgation of the 2010 Constitution? But when we focus on that particular law, we have had cases of sexual harassment, issues of unfair wages, and the laying off of workers, which have been done discriminatively. So tonight, we'll be debunking that particular topic and ensure that our viewers, in case they are aggrieved by their employer, they get to know what to do and what is the recourse. My name is Irene Mwangi, but before I get into the conversation, let me allow my guest to introduce himself.
Thank you so much, Irene. My name is Dr. Latemo Tom, the Deputy Executive Dean in the School of Law here in Parklands campus. And I'm also a lecturer at the school. I teach several units, one of them being labor law.
All right.
And I've also taught a number of other units like constitutional law, criminal procedure, and medical law.
All right.
Yes. And apart from that, I'm an advocate of the High Court of Kenya. And I do consultancies, and a number of other issues.
All right. The description has been so big, I thought to myself I would be unfair to introduce you instead of you introducing yourself. But before we get into the nitty-gritties of the discussion, perhaps we could bring the discussion into context to look at what the law says concerning labor relations. How has the journey been before the promulgation of the 2010 Constitution? What governed us then when we had, the colonialists to the far that you have come? Can you contextualize the discussion before we get into what you're facing currently in the country?
Yes, thank you. It's a very nice question. In that we have come from far. Initially, if we look at what existed here in Kenya, a number of issues were being raised on how the employee used to relate to one another. And before, even at the time of colonial, I really appreciate for having mentioned such a thing. We were being governed by the Contract Act 1872. And of course, that's a law which was made in India and it was being applicable here in Kenya. And after that, after the independence, we were now having our own laws in place to govern employee-employee relationship. And towards up to 2007, before that, there were a number of laws which were repealed. But of course, through a task force that was formed by the AG, we have now 5 key laws, labor laws, which govern a number of aspects in law. Of course, relating to the employee-employee relationship. One key one is the Labor Relations Act.
Okay.
Yes, which now essentially talks about how the employers are supposed to be relating with the employees and their rights and duties, etc.
Okay.
Yes.
All right. So the issue of labor relations was not quite relevant, so to speak, in the country, because it was not something that faced, say, Kenyans within one period of time. But when it came to the COVID-19 pandemic, I think now Kenyans got to probe question concerning what does the law says on the issue of labor relations, because at the time we are having massive layoffs due to the pandemic that was something not anticipated. So when you look at that particular issue and you focus on the issue of labor relations, did that particular pandemic make Kenyans to stay woke in terms of the question of how do you relate to your employer? Because then that brings the aspect of labor relations.
Yes. You know, it's important that there must be an harmonious relationship between the employer and employee. And that relationship automatically is in one way or another is enshrined in the contract of employment, because the contract itself is the one that, of course, gives provisions, various provisions on matters employee-employee relationship.
Yeah.
So if maybe one of the provisions of the employment contract is violated by the employer, then you can see there are some problems in between the two of them. Now, at the time of COVID, there were a number of issues which were raised.
Yeah.
For instance, most contracts did not even anticipate that there should be something like that. So the employers did not design, even the employees did not expect that such a thing. So they came up with several measures to ensure that they remain afloat. And one of the things that the employers did was to ensure that they reduced the number of workforce that they had. And by reducing such number of workforce, it means that several people are going to lose their jobs. Some of them, they were not following the law in ensuring that once they terminate the contracts of the employees, due process is followed. And to that extent, like for instance, you may find that people at the time of COVID, people were either forced to go for unpaid leave, or otherwise their contracts were being terminated, or in some cases you may find that the employers decided to reduce their salaries or remuneration. So that one now, it caused some conflict between the employers and employees. If you remember the case of the Kenya Airways and versus the aviation, the union for the Kenya Airways, there were some issues at that. Some people were being laid off, and when the trade union went to court, it was the court held that the due process was not followed. And some of them, in fact, were taken back to continue with their services. And it went ahead to say that, okay, they have to compensate if you have to terminate their services. If their services are no longer needed, they have to be compensated before they leave. So that's how it is. But initially, if I answer your question, or the question that you said, that initially, when you look at the labor laws, people never used to follow them.
Yeah, I never used to follow it. It was just the law was there, but the activation of the law was not as much.
Yes, enforcement is an enforcement issue because most employers try to ignore those laws, or some of them they do not know whether they exist at all. And even at the time of when the colonies were in Kenya, you find that most people are being forced to work, and forced labor is unconstitutional right now. Yes, it's unconstitutional. So that's why you find that there are several things which happened at that time and even at present, simply because of ignorance of the law.
All right.
Yes.
So when you look into labor relations, these are two people relating. When you talk about relation, it's one group and the other. It's some sort of a relationship. Therefore, there is the law that govern both ends. So what does the law say concerning cushioning the employer and at the same time cushioning the employee? What are the different laws that govern these particular two groups who have to have a synergy to ensure that there's a seamless working relationship?
Good question. There are several laws, by the way. One of them, even apart from the registrations that we have in place or the statutes, we have to start with the Constitution. Okay. The Constitution, is the supreme law of the land.
It is. And
it contains key provisions in that if any person violates, of course, they end up now being, of course, they have to meet the penalties. Some provisions of the Constitution which are very key. For instance, number one, if you look at Article 41 of the Constitution, it talks about labor relations and how they should be treated. The employer, employee, the issue of collective bargaining, etc. Apart from Article 41, we also look at Article 27 on equality and freedom. Because in this case, you find that most employees, particularly women, the children, the youth, are discriminated against on various bases. For instance, sex, for instance, you find issues of religion, issues of race, etc. So Article 27 comes in to protect them. Apart from Article 27, there are some other provisions of the Constitution which really promote the issue of now having a good relationship between the employer and the employee. For instance, Article 41, a very important key provision. Article 23. You'd also look at Article 48 of the Constitution, the right to access justice. It's very, very important. Article 162, which of course talks about the formation or establishment of the Employment and Labor Relations Code, is also equally very important, and a number of other provisions. So apart from the Constitution, we also look at the Employment Act, which is now the key legislation. The Employment Act, it contains various aspects, various provisions. It talks about the employer-employee relationship. It talks about how you come up with the employment contract. It talks about the rights and duties of employers and employees. It talks about the issues of insolvency of the employer. It talks about issues of termination of contracts, because now this is the key thing. Because if you terminate the contract, there's no good relationship.
It's done.
Yes.
All right.
So the employment, it contains some minimum provisions or minimum requirements for any employer to follow.
Okay.
And also, apart from the Employment Act, we also have the Labor Relations Act, which now talks about now the employer-employee relationship. So the the Labor Relations Act, there are several provisions like now establishment of a trade union and an employers' organization. How is it established? And you also talk about issues of funds of unions.
Okay.
You know, if there are both employers and employees unions. It also talks about the properties, how it's supposed to be managed. Because if you don't manage the property of the union well, then of course
there'll be problems.
there are always wrangles. So it also talks about issues of having officers now of a union. Who can be an officer of the union? Remember, minors cannot be officers unless the person has attained the age of 18. They cannot be officers, considered as officers of a union. So who can be appointed to that office? Those are some of the provisions in the Labor Relations Act. So apart from the Labor Relations Act, we also have what we call the Labor Institutions Act. It's equally a very important act in that it establishes the National Labor Board. And the National Labor Board is the one that advises now the Cabinet Secretary in charge of labor on a number of issues, including remuneration, including issues of incorporation of international standards.
Okay, it's domained under the Ministry of Labor?
Yes.
Or the board itself?
No, but that is a statute.
Oh, okay.
Yes.
All right.
So it talks about a number of aspects whereby they need to advise the cabinet secretaries to come up with some provision. If they need to amend some, like for instance, a provision in the Labor Relations Act or the Employment Act, then through that, it is the one that's charged with the advising the cabinet secretary to come up with a certain amendment, so that Parliament can pass through.
Okay.
So apart from the Labor Institutions Act, we also have what we call the Occupational Safety and Health Act, or otherwise OSHA in short.
To shorten the name.
Yes. So this one, it's basically for the health and the safety of the employees. Remember, the workplace, the employer must ensure that employees are safe. The working environment should be safe. Yes. But you see, in most instances, you'll find 100 employees working in a 10 by 20 room.
Yeah.
And with that now, there's not enough room for them to mingle out, to even fresh air, issues of light, because at the place of work you need to have sufficient or adequate light at your office. But if there's no adequate light, if the ventilation is not properly done, then there must be issues, of course.
Okay.
And the employees will be fighting with the employer now and then.
Yeah, every now and
Yeah,
then
so-
it's a concern.
Yes, a very big concern. So then it's a requirement of the law that the employer must ensure that where the employees are working, it's a safe working environment. And it's, of course, convenient for them in that you should not be having a kitchen behind the workplace and you find maybe the kitchen they're using firewood. There's a lot of smoke.
There's a lot of smoke.
Yes.
These guys have to work, but now they
Yes.
can't concentrate because of smoke.
Because of that, you find several things happening. Okay, or in some cases, you may find that maybe it's an industry, and maybe industries that manufacture sulfuric acid, and or
Hazardous
these
fumes.
hazardous chemicals, whereby fumes, of course, they may affect the health and safety of the workers. So the employer must ensure that those things are complied with. So it's it's very, very important for employer. Okay, apart from that, we also have what we call the Work Injury Benefits Act. I know this act has been so much contagious in the past because if you remember, there was this case which was filed by the Law Society of Kenya against the AG or the Attorney General, whereby a number of provisions of the act were in fact annual. Or, the court said that they were not constitutional in nature.
All right.
But with time, the case, of course, the AG filed an appeal, and it was, of course, lifted. And actually, the act itself, it provides for compensation.
Okay.
Because at the workplace, several things happen. It can be,
You're prone to accidents.
yes,
So
there are several accidents which may happen. So not only accident, there can be an accident whereby a person is normal. He dies.
Yeah, it happens.
I think even remember there was one issue, I think it was in Thika, whereby some 2 employees fell in a boiling tank.
Yeah. Remember
so-
there was a case that was filed in court.
Yes. So in that case, the employer must be held liable if there were no safety gears which were put in place. And now that takes us back to the Occupation Safety and
what the
Health
law
Act.
says concerning such a situation.
Yes, so in that case, the employer must be able to compensate. Yes, in case of death, there are several provisions in the Works Injury Benefits Act that requires the employer to compensate. In case of injury, there can be partial injury or disablement or permanent disablement, where the employer is also required to compensate. So those are the laws that are in place to ensure that the employer-employee relations are intact.
All right, but before we take our first break, let's look into the issue, into that particular law in terms of occupational safety. When we have cases whereby an employee is exposed to risk to the extent of maybe being injured or sometimes losing their lives, does an individual have to go to court to seek recourse, or does the law elaborately say that in case this happen, you have to pay this fine, or are they governed by their own laws when they break down the specific act to sort of put it in their context? Do they have to go to a court of law to seek compensation from an employer in such an incident?
Okay. Apart from, before even you now go to court, there are a number of things which must be done. For instance, it's important that the employer should report that case to the nearest labor officer. So after reporting that incident, then of course the next of kin are also informed of the accident. And then after that, the employer is required to pay compensation.
All right.
Okay. So in some cases, you may find that the employer does not want.
Yeah.
Okay.
So that's
Maybe the next of kin is demanding a lot of money,
okay.
and the employer does not want to do this. But to keep in mind, under the Works Injury Benefits Act, there is a schedule there. It includes the list of all diseases, all types of injuries and all those. So in that, if anything that happens that's under that schedule, the employer must pay.
With strict instructions of what the act says.
Yes, says the employer must pay. There's no option for that.
Okay.
But if he refuses, then you have a right to go to the court. So the person, maybe the next of kin can go to court, or the person who has been injured can go to court, or any interested party, even the trade union itself, they have a right to invoke the jurisdiction of the court.
All right.
Yes.
Thank you so much, Dr. for that particular perspective. We have to take our first break. Dear viewers, we have to take our first break. We have barely scratched the surface when it comes to this particular discussion, but once we return from our break, we'll be looking into what the law says concerning the different contracts that workers have here in the country. Don't go far.
Vera Beauty and Fashion College is focused on being the leading technical and vocational training institute in the region. Our team possesses in-depth knowledge and extensive experience in the industry, offering thorough training in cosmetology, hairdressing, interior design, creative arts, training of trainers, nail technology, and fashion design. With branches in Nairobi, Thika, Meru, Eldoret, and now in Mombasa, our courses ensure that learners are completely equipped with knowledge, competency, and employability skills. Enroll today to be a part of the Center of
kwenye mitindo ya kipwani.
Nguo yangu wasenesi makire mtuzeha sana nena finira chechemekwe. Nguo yangu wasenesi makire mtuzeha.
Yani unavyoona basi niko kipwani pwani tu.
Wali unapopika inatakana uwe uko half cooked.
Bageri.
Niko katika kaunti ya Kilifi, magavazi ya Gede.
Stream live mitindo ya kipwani on our KUTV Facebook page every Saturday 4 p.m.
Hello everybody, I'm Nena.
And I'm Gigi.
Welcome to Engine Season 2.
The place to find out about the world we live in
and the creatures that we share our planet with.
Join us on the most exciting adventures across the African continent.
See breathtaking wildlife, stunning landscapes,
and out of this world technologies.
Meet incredible scientists
and learn fantastic facts.
Explore, discover, be amazed.
Be part of the next generation of African change makers.
Be a part of Engine, Africa's #1 science discovery program.
Yay!
We're learning every day.
Let's go!
Engine leads the way.
Welcome back. You're watching Law Matters. Tonight we're discussing the issue of labor relations and what is the relationship between the employee and the employers. We're having Dr. Tom here tonight, debunking this particular discussion, of course, getting into context concerning what the law says concerning this particular sector, which affects employees as well as employers. So, Dr. Ari, we were looking into the issue of employers. And once you get into the employment sector, you realize that you can be in the same organization and not be eligible to the same welfare or say rights because of the different contractual agreement, which is the binding agreement between the employee and the employer. So could you kindly give us an elaborate setup of the contracts that we have here in the country?
Thank you. It's a very nice and simple question. In that you may be working at an institution, but you are having different types of contracts. So there's various types of contracts that the Employment Act recognizes here in Kenya. And of course, people just may contend, why should I be given a certain type of contract, yet the other person is not having the same? For instance, you may find somebody having a casual type of contract, in that a casual contract is, in simple terms, is a contract whereby the employee is engaged on a daily basis, and that employee is paid at the end of the day. So once that work is done, the employee is paid. And at that time, there is no need to have what you call a notice of termination of the contract, because you have just paid him, everything is done.
There's no relation beyond
relationship. Okay. So apart from that, the employee himself or herself is not required to remit what you call the statutory requirements, like now the NHIF, the NSSF, the pay as you earn. The employee is not required to remit that. Another type of that contract, or before even I go to the next type of contract, you find that in casual type of employment, you find that there are some benefits that other employees enjoy. These people cannot enjoy. For instance, a leave day. Okay, simple thing like going on leave, they cannot. Okay, and there are some allowances also, of course, which they don't enjoy. And before the person is terminated, just as I mentioned, there's no need for that person to be given a notice. You work, that is it.
I pay you money,
that is it.
We are done.
Yes. But you may find that the person is working for more than even 2-3 months under that casual terms. And remember, this casual type of employment is very good for seasonal companies, whereby they engage some people for a few days and then
they dispose over time.
So after that, we find that it's most employers really they are interested in having such type of contracts, because they don't need to remit like NHIF, NSSF, and all those things.
It's easy for them.
Yes. But when it goes for more than 3 months and the person is just engaged to do that work, and maybe that person is not given a leave, then the person has a right to go to court and, of course, demand for leave days worked, and that person can be paid. And another thing that you need to keep in mind is that if it goes for more than 3 months, that person has a right to demand for change of terms.
Oh, really?
Yes.
But do we implement the law on that particular basis, or is it that Kenyans do not know? Because big institutions and big employers, so to speak, have employed people even for more than 1 year and disposed them over time, quote unquote, for lack of a better word. Is it to say that, maybe the employee is not aware, or it is too expensive to go to court to compel an employer to employ you on a formal contract?
Yeah, you see, that's one of the things that they use to ensure that they are not, of course, they don't meet the requirements of the law. They engage them for a number of years, period of maybe 1, 2, 3 months, 4 months, even 1 year, 2 years. But if that employee goes to court,
they can have their way?
Yes. And apart from that, what we also need to keep in mind is that the employee himself or herself must ensure that he is paid at least for 1 day, because if he works for 6 days, they must be given 1 day off, and that day should be paid off. The employer must pay for that particular day.
But it doesn't happen most times.
Yes. So at the end of the day, you find that most employers do not do that. And to ensure that they escape from all those requirements of the law, they engage those employees for maybe 1, 2, 3 days, and then they take some other people, and then they bring on board these employees to ensure that it's not consistent. Okay. So at the end of the day, you find that most employees, they are unable even to go to court. And the other thing, you see, when they pay those employees, they ensure that they pay them in cash.
Okay. Oh, so there's no...
So there's no evidence.
Yeah, there's no... you can't trace the transaction.
Yes.
Okay.
There's no evidence that the person was engaged. And even if it was an oral contract or something like that, there is totally no evidence.
But then again, it brings the question, if I go to court, I've been employed as a casual worker. For a period of 1 year, I go to court, the court compels the employer to employ me for a formal contract. Can the employer escape from that particular court order? Can the court really compel an employer to employ somebody if, for example, they might decide to say, we do not have the money to employ that particular person, therefore, even if the court order is saying this, we are sorry, we can't be compelled due to our financial situation?
Okay, good question. The court can never do that. Remember, a contract is between the employer and the employee. They come, sit down, negotiate, agree, and then sign a contract. So you may find that maybe the employer does not have enough funds.
Okay.
What next? You cannot compel him to employ him.
Okay.
You can't. So, or otherwise, the employer does not need that person because he's not skilled. You see, maybe a type of work which is supposed to be done, someone else is doing it much better than the other person. So it cannot compel the employer to do that. Never.
So what does the court do? It gives instruction in case I go to a court of law and seek recourse in that particular situation. Is it that they are given directions to do at their own will, if they so feel, or now how do I get recourse as a casual worker who now wants this thing to move to the next stage?
Now, the first thing that you need to establish is that there must be evidence to ensure that you are working there. And you see, it's important for you to ensure that the court to ensure that you are actually an employee of that particular establishment. Once the court determines that, then it goes to a next step of ensuring for how long, what is the duration that you have been working there. If they find out that it's more than 3 months, then the court has, they can order the employer now to change terms of employment.
They can order?
Yes. But if the employer also is not willing to do that, then of course it goes to an extent of having now the employer of I think the best thing, even instead of now going through all those processes, let the employer and employee sit down, negotiate for the terms, sign a contract, and that is the end.
So it's some sort of out-of-court settlement of some sort.
Yes.
All right. Now, it brings the question of the issue of freedom of association, because sometimes when workers come together, it is when they find a voice. Sometimes when you are sacked alone, it is very hard to seek recourse in case you feel the law has been flawed in terms of labor relations. What does the law say concerning freedom of association? Because we have seen cases of discrimination when people come up to sing Solidarity Forever or whatever tune they sing to agitate for their rights. What does the law say concerning freedom of association so that they can, have a free voice to come up to their employer?
One thing you need to keep in mind is that freedom of association, not only that it's in the statutes, it is also in the Constitution. So if you look at Article 36 of the Constitution, it's very simple. It says that everybody has a right to associate. Okay. And that right extends to the right to participate in the activities of a union. Now, I talk of the trade union and employers union. So apart from participating in the activities of the employers union, they also have a right to leave that union. You see? So all these things. Now, apart from the Constitution, Article 36, look at the Labor Relations Act. It also ensures that the employees have a right to associate. Okay. So they can come together, fight for their own interests, to ensure that their interests are well catered for by the employer. In some cases, that's why we say that most employers decide to use some means which are not really permitted in law to ensure that they gain. You may find, like, for instance, because of COVID, most of them decides to do away with some employees based on the fact that they did not like them. You see?
It gives them an avenue to...
Yes, just do away with them. So, but at the end of the day is that the question is, did you follow due process?
Did you follow the law?
If due process was not followed, the employer goes, he has to meet all the penalties enshrined in law. Yes.
All right. So freedom of association brings the aspect of trade unions that you have had. I think the biggest, federation you have had in Kenya is KOTU, led by Francis Atoli, the politician come businessman, depending on how you may call him. What does the law say concerning the establishment of trade unions? Because sometimes we have seen the employer discriminate the employees or sort of frustrate them when they are creating the trade unions, because they see sometimes this will be the giant that will swallow their institutions in days to come. So how are they governed, and how can they move forward concerning this particular issue?
Okay. So once, it all depends on the type of employment a person is engaged in, or the sector. Now, if employees want to establish a trade union, the first thing and most important thing is that they have to ensure there are at least 2 members of amongst all the employees. They have applied for what we call a certificate of establishment of a trade union. So, and of course that is under the Labor Relations Act. Once that application is made to the Register of Trade Unions, the Register of Trade Unions must look at the application, ensure that it's compliant. And some of the requirements are that there must be at least 2 people who are making that application. They must sign that document. They must also ensure that they have submitted the proposed name of that union. So once that is submitted to the Register of Trade Unions, the Register of Trade Unions has at least 30 days to act on that application. So if all the requirements are met, then the registrar goes ahead to issue that certificate of establishment of a trade union. But it's not, remember, that is just a certificate. You need to make a full application. So the full application for that now union must be done within a period of 6 months. So it's a requirement of now the promoters of that union to ensure the application is submitted back to the Register of Trade Unions. And of course, they must submit a number of other documents along with the application, and also the prescribed fee. For instance, there is need, I know it's a little amount, there is need to have a stamp of at least 20 shillings. And apart from that, they must submit the constitution of that union. Apart from the constitution of the union, they also must submit minutes, because the employees must have sat down,
reached a consensus,
negotiated, and then reached that consensus and said, okay, we need to establish that union. So they must come up with minutes, and also they must ensure that all the employees, they must also submit a list of employees to the Register of Unions, and those employees must work in that particular sector. Okay. And now at that time, remember, initially only 2 employees were required.
But at this
perform, yes.
At this stage.
Now, when they are submitting the full application, they need at least 50 employees. So once that application is submitted to the Register of Trade Unions, he looks at it again for the second time. And ensures that the name that has been submitted, or the proposed name for that union, is compliant, in that it should be distinct, should not be similar with other names of the existing unions. Yes. So once that is done, the employee ensures that it has met the minimum criteria, that is the 50 employees, and they have made the application. 7 employees have submitted that application. So once that is done, he goes ahead to issue now the full the certificate of what? To that union, that is compliant. However, there can be some circumstances whereby the Register of Trade Union decides, oh no, we need some more information from either the members or the employers, or some other parties, or another union can come and say, no, they're using the same name. Yeah. So in that case, he also seeks some further information to ensure that by the time he hands over that certificate, it's fully compliant.
Right.
But even if he goes ahead and hands over the certificate, there are also some circumstances whereby the union can also be of course, that certificate can be withdrawn. For instance, if it was issued under fraud, maybe this,
corruption in
for
Kenya.
us, yes, or under mistake. So in that case, it can be withdrawn by the Registrar of Trade Unions.
All right. So once we have formed the organization, and of course, speaking about the trade unions that we are having here in the country, we have had the cases of teachers' strike, and some of the teachers are under NAT, while others are under KUPPET. So when they started agitating for their rights, they were all having a strike. Then in between the negotiations, one party decides, we are not striking anymore, we have reached a consensus, teachers, please kindly go back to work. But you find the other organization, KUPPET, is saying, no, we are still adamant, we have not reached a consensus. So you find a situation whereby, say 30 teachers go back to school, then we have these other 15 who are saying, our union has told us to stay put. Then we have the government saying, teachers, if you don't resume work on Monday, consider yourself fired. So where does the employee stand when there is this push and pull, and somewhat they are not singing in one voice, given that one party has decided we are good to go?
Yes. It's a very interesting question, because you may find that some unions, in a particular sector, there can be one or two unions. Like now, KUPPET and NAT. So in such a case, one union can decide, okay, we call off the strike. The other one goes on.
Yeah.
So in such a case, you find that the members of that particular union, which has of course called off the strike, they're the ones now to go back to class. But the others cannot.
Yeah.
Yes. Yeah. And it all depends. Was the strike initially, at the time of declaration, was it legal? Yes.
So it must be legal.
Yes, because there are some requirements of the law.
Yeah.
Yes, before you go on strike, you must have given the notice to the employer.
Okay.
And now TSC, and that notice must be given to TSC.
Yeah.
And if the notice was not given, it means that the strike was illegal. Or if the notice was given, they can give a notice
which was not
today, and then tomorrow you go on strike,
which has not been served. You have not served the notice.
Yes.
Surely.
So in such a case, you find that that is illegal. The court can compel now those people who are on strike, or the employees on strike, to go back to class. Okay. And that happened. Previously, it has happened in a number of days, in a number of cases. So they compel them and ensure they go back to class.
Work,
Yes.
To class, yeah.
Yes. So in that case, the employer must balance also.
Okay.
Because some cases might be genuine. Some of the grievances there's a meeting, they're genuine. Right now, the case of in northern side of Kenya, you find that those teachers really need to be paid hardship allowance, and the employer does not pay them, and so they decide to go on strike.
Yeah. Because it's unfair, given that looking at their counterparts in Nairobi, they're enjoying the city sun and of course the cool air in the city, but you're another corner of this country and still you're not receiving compensation for that. So the employer must really look into such situation. But then sometimes the government is still adamant that, you go back, we'll pay you, but it's not something that really happens.
Yes.
Okay.
So even if they go back, the question is, you have what we call the return to work formula.
Okay.
Did they enter into that?
Okay. Was it binding?
Yes, yes. Because if there's no such document, it means that the employers will be in shit, because they might be victimized by the employer by saying that, okay, for this particular number of days, you did not work, we are not going to pay you.
Okay, yeah.
See?
Yeah.
So there must be such a form, a document to ensure that they are covered before they go back to work.
Okay, yeah.
Yes.
There must be something binding.
Yes.
Okay, we'll have to take a break due to that particular discussion, but once we return back, we'll be having a discussion on domestic workers in Qatar or Middle East. It has been a concern among Kenyans concerning their welfare and what the law says concerning this particular group. That and much more, including the question and answer session. Stay with us.
Vera Beauty and Fashion College is focused on being the leading technical and vocational training institute in the region. Our team possesses in-depth knowledge and extensive experience in the industry offering thorough training in cosmetology, hairdressing, interior design, creative arts, training of trainers, nail technology, and fashion design, with branches in Nairobi, Thika, Meru, Eldoret, and now in Mombasa. Our courses ensure that learners are completely equipped with knowledge, competency, and employability skills. Enroll today to be a part of a center of excellence.
We are all seeing the impacts of climate change. In Kenya, for example, the frequency of the floods is becoming more and worse. The amount of people and livestock we're losing.
The level we need to go is a level where the normal mwananchi and also the government stakeholders can uptake these solutions.
Those small acts multiplied by millions of us will help make a difference in the world at the end of the day.
It's just a slight behavior change that we need, and you'll find that it serves us a bit more than you put in. And that's the goal. We want to live a better world than we found, because at the rate we are going, it's dire.
We will secure the planet for future generations.
Lola ni programu inayokupa fursa ya kutizama video zozote pindi tu unapokuwa na nafasi. Hadithi za kukupa motisha, drama, maisha ya vyuo vikuu, teknolojia, masuala ya jamii, kuzuru maeneo tofauti, spoti, burudani na zaidi. Pata programu ya Lola sasa kwenye rununu yako kwa yote unayohitaji.
Thank you so much for staying tuned. You're watching Law Matters. We're discussing the issue of labor relations, that is to say, the relation between the employer and the employee. We're having Dr. Tom debunking this particular topic. Now, Dr. looking into the issue of labor relations, we have had concern concerning the issue of domestic workers who go to Middle East to offer employment. The issue has caused an uproar in the country to the extent that people have said we don't need to send our domestic workers to Middle East, given the issue of sexual harassment, the issue of unpaid wages, even death in terms of people who get sick in the line of work and don't get the treatment that they require. What does the law say concerning this particular situation in terms of the laws we have in the country and even beyond our borders, and what can be done on this particular issue in the context of the law?
Yes. Now, the domestic workers really, I'm so sorry to say that most Kenyans are really suffering. And because of poverty, they are now seeking employment abroad in several other countries, particularly the Middle East. So you find that they are not aware of the laws, either in Kenya or in wherever they are going to. So particularly in Kenya, we have the labor-related laws, whereby you find and the employment agencies, they are regulated. So they are regulated in the sense that they have to be, there are minimum criteria of which they have to submit to the government before sending such people abroad to various countries. But now the issue comes in when they go to, like now, Saudi Arabia. It has reported a number of incidences, Qatar, yes, and some other Middle East countries. When they go there, does the law of Kenya apply in Saudi Arabia? No.
It doesn't.
Because these are two different jurisdictions. Yes. So in that case, the law in Saudi Arabia applies. And if in case of death, unfortunately, in case of death, then of course death is a crime.
Yeah.
Either Kenya, in Saudi Arabia, or any other part of the country, the people who are there, they must be held liable. The employers, they must be held liable for that. But now we find that most of these things, even though they are reported, they are not acted on. You see, that's the main problem. And the other major problem is that you find the people who are going, the Kenyans now in Saudi Arabia, they don't register themselves with the Kenyan High Commission in Saudi Arabia. So the Kenyans, the commissioner there or the ambassador there is not aware of these Kenyans.
Any such Kenyans in that particular country.
And for them, I've heard of cases whereby the person, when he or she arrives in Saudi Arabia or in any other country like in Qatar, at the airport itself, their passports are confiscated.
Okay. So
and you can never travel without that passport.
Move, you can't move without that.
So with that, they ensure that these people, they cannot move.
They're trapped, so to speak.
So it's unfortunate that these things are happening, and the government needs to really wake up and do something to ensure that our Kenyans in Middle East, they are really protected, and they enjoy the other rights of other people, just like here in Kenya, in Saudi Arabia.
Okay. All right. Finally, what really caused an upset between employees and employers? What is the main cause of friction, and how can this be addressed? Before we get into the issue of question and answer, and give our audience the time to, of course, ask you questions.
Yes. There are several factors which may cause some friction between employers and employees, or rather, it's the trade union and employers. In some cases, remember, when you are employed, you have an employment contract. And that contract, it stipulates a number of provisions which, of course, the rights and duties of both parties of employment. So if one of the provisions in the employment contract is violated, there's some friction.
Okay.
For instance, in most cases which are reported, is the issues of remuneration.
Yeah, that's a major issue.
Yes, maybe you are engaged and you're supposed to be paid 80,000 a month or 75,000 a month. The employer decides to say, okay, there's COVID. My revenue has really declined, so I need to pay you 60,000 this month. Or otherwise, at the end of the month, I need to pay you 30,000, you see. But the contract stipulates that you need to be paid 75,000. So if there is such kind of arrangement whereby the employee is not involved, of course, their cases are rising. That's one of the things. Working condition is another one I said. Remember I said that you are working in an environment whereby there is a kitchen behind, and there's a lot of smoke. So, and you see the employee, the trade union goes ahead to inform the employer and maybe to relocate that kitchen. But the employer does not do that.
Okay.
And then issues arise between the two.
All right, Dr. I'll have to cut you short there. And of course, give our audience an opportunity to ask you a question concerning this particular discussion. Of course, they might be having some of the interesting questions to ask concerning the issue of labor relations. You'll be given an opportunity to ask a question. Kindly introduce your name and ask Dr. your question.
Okay, thank you. You've really explained a lot. My name is Alex. You've really explained a lot. But however, I'd like to know what's the difference between wages and salaries.
Okay.
Thank you.
Dr.
Okay. Now, it's, when you are paid, for instance, on a daily basis, you receive wages. If you are paid at the end of the month, you receive salary. Okay. So it's a very simple thing.
Yeah.
Wages is for a shorter period, and then salaries is for maybe a month, or in some cases can be on how you negotiate between you and your employer.
All right. Yes. Okay. Yes. Thank you so much, Alex, for that particular question. Next.
Thank you. My name is Kelvin Kimani, and my question is in regard to settling employment disputes. So I'd like to know, Daktari, what is the importance or what are the advantages of the use of alternative dispute mechanisms in settling these employment disputes?
All right, thank you, Kelvin. Somebody else who has a question?
Okay, my question is, the law states that when a worker works, he should work for a minimum of 8 hours in a day and 48 hours in a week.
Okay.
Bearing in mind that most of the workers in Kenya are from the informal sector. That is, how have we committed ourselves in ensuring that these workers need to know their rights, and in case that they work overtime, they should also be paid. So what are the steps that the country has made in ensuring that the workers really are aware of their rights? Because
Thank you for your question. I didn't get your name, sorry. Ruben, thank you. Dr. kindly answer the question by Ruben and Kelvin.
Okay, Kelvin, you have asked a question on the benefits of having the ADRS or the alternative dispute resolution mechanisms versus now going to court. It's simple. You know, in ADRS, you have several other mechanisms, like now conciliation, arbitration is there, and the other one, mediation.
Okay. Yeah.
So if you adopt that, it's cost effective. In that, remember when you are going to court, you are going to file some
case, you find a lawyer.
Yes, and you have to bear legal fees, filing charges, etc.
Yeah.
Apart from that, it is time consuming. If you go for arbitration, maybe your case can take 1 month.
Yeah.
If you go through the court system, it can take even 5 years for that to be settled. Okay,
right.
So adoption of ADRS mechanism is much better than going to court.
Okay.
And even the issue of the kind of relationship, when you're going to court, when you go back to your place of employment,
there's just some tension there.
Yes.
So it's better when you know it's more amicable.
Yes.
Okay.
So on the second issue of working hours by Ruben, remember we have what we call the wage orders under the Labour Institutions Act. And in that, it stipulates the number of hours that a person must be, of course, working in a particular day. So it's not automatic that it should be 8 hours. No. You find, like now, for instance, if you look around in streets, in cities, you find that there are security officers. They work for more than 8 hours. In some cases, 12 hours. Sometimes 16 hours. It all depends between the employer and the employee.
The contract agreement.
So if that is, of course, under of course, enshrined the contract of employment, you find that you must work within those number of hours that you've been given. Beyond that, the employer must pay what we call for overtime. Okay. So if the employer is not ready to pay, you have a right now to go for institute your case. Go to court, or otherwise use the internal mechanisms which are there in place first before you go to court.
All right. Thank you, Dr. Tom, for answering the question, of course, from our audience. Finally, because of time, tell us, looking into the law, how implementation has been done as you give your final remarks concerning this particular discussion.
Yes. Now, on the question of implementation of the labor laws in Kenya, we may rate it at 6 out of 10.
It's beyond above average.
Yes, we have really tried, but there are some gaps still, because most employers really try to violate the rights of employees. But the employment laws, they're really there to protect the employees at the workplace. So I may finally say that it's high time right now for the employer to ensure that they follow the law. And of course, it's not only for the employer, it's for the employees as well. Because you cannot expect something from the employer, yet as an employee, you are not bound by the rules and the regulations of the employer, which are supposed to put in place. So you must ensure that you follow those rules as an employee. And then the employer also plays his part. So with that, then the kind of relationship that we have at the workplace will be something that we really appreciate as a country.
All right. Thank you so much, Dr. for your perspective concerning this particular discussion.
Thank you.
All right, that's it for Law Matters tonight, the discussion being labor relations and what the law has to say concerning that. We have to thank our audience for their questions that have emancipated this particular discussion. You have heard, information is power. Know what the law says concerning what should be done by your employer and what you should do as the employee. Stay woke. Thanks so much for watching. Have a splendid night. My name is Irene Mwenge.
Vera Beauty and Fashion College is focused on being the leading technical and vocational training institute in the region. Our team possesses in-depth knowledge and extensive experience in the industry, offering thorough training in cosmetology, hairdressing, interior design, creative art,